Hi again, we're back for the second set of video lectures referring to the Human Rights Tribunal content for TRIB 2303. So you either received the first half of those in class with me, or you watched them via video link, depending on which section you're in. And so that means we're picking up today the slideshow at slide 21, which talks about pre-hearing process. So at this stage, the application and the response have been processed by the tribunal, and then they launch into this next stage. So first thing that happens is the confirmation of hearing is sent out, and that's essentially a notice of hearing. It outlines the date, the time, and the location of the hearing for the parties. The important thing about the confirmation of hearing date is that from there, the limitation period dates start to run. So the first one is that within 21 days of the confirmation of hearing, disclosure has to occur. And disclosure, of course, is important because in our legal system, we expect, for the most part, there are some exceptions, i.e. the Landlord and Tenant Board, but for the most part, the other party has the right to know that case is against them to help them prepare with their theory of the case and with their arguments to present at the hearing, right? So disclosure occurs within 21 days of the confirmation of hearing. It does not need to be filed with the tribunal at this stage. However, statements of delivery must be filed with the tribunal. And then 45 days prior to the hearing, this is the deadline for parties to provide to the other side a list of each document that the party intends to rely upon at the hearing, and either a copy of that document, if it wasn't previously provided, or confirmation that it has been previously provided. So required disclosure is essentially a list of all arguably relevant documents in possession of the party. A relevant document is a document that's going to have some relevance or connection to the issue in dispute between the parties, okay? And a document that the party intends to rely upon at the hearing. There is an ongoing disclosure obligation, so if any new documents arise or come to a party's attention that they intend to rely upon at the hearing or is relevant to the case, then they are required to provide that as it becomes available. So what constitutes documents? Well, documents is the term that's used to encapsulate a bunch of I guess, evidence that you might rely upon. So documents could include, I lost my train of thought there for a second. Documents could include actual written documents, pictures, any recordings, either video and sound, charts, maps, graphs, any of those things constitute a document, okay, for the purposes of disclosure. It's important also to note that if there is a rescheduled hearing for any reason, those dates do not change, so that 21 days after confirmation of hearing for the disclosure, as well as 45 days prior to the hearing, a list of documents that the party must provide to the other side, those do not change unless the tribunal indicates otherwise, okay? 45 days prior to the hearing, also, a witness list has to be provided to the opposing party and a statement that each witness is going to rely upon. Witness statements and testimony are restricted to facts and not opinion. The exception to that is if you have an expert witness who's coming, and expert witnesses can often provide their opinion because that's why they're there before the tribunal, to provide their professional opinion about something. A case assessment direction may then be issued. A case assessment direction can come as a result of the tribunal reviewing the file and then determining that maybe there needs to be discussion between the parties about the witness list or some evidence that they've mentioned that they intend to rely upon. Okay, so case assessment directions can be issued. A case assessment direction meeting often occurs via conference call, just for ease of attendance. That makes most sense. And whatever comes out of that call is considered to be a direction from the tribunal, okay, so a decision from the tribunal. Mediation then occurs, and as you know, can occur if both parties have agreed to mediation, to enter into the mediation process. So when you completed your application and responses, you would have indicated for the applicant and for the respondent if they were interested in mediation, right? So if both parties haven't expressed an interest, then the tribunal will send a notice of mediation with a date, time, and location on it. There is a mediation practice guide available on the Human Rights Tribunal website. confidentiality agreement must be signed. If the parties are successful in their mediation, then a Form 25, which is a confirmation of settlement, must be signed and filed with the tribunal. Okay, moving on to other pre-hearing processes then. Preliminary hearings might be necessary, but they are not required, and we've talked about preliminary hearings in the concept of a few other tribunals this semester. They're really used if there's an issue that requires some kind of attention, so perhaps a jurisdictional issue with the tribunal. Does the tribunal have jurisdiction to deal with something that was raised in the application, or do they not? Are there outstanding procedural matters that perhaps need to be addressed early on, okay? Parties will make submissions at preliminary hearings. They may present evidence if it's necessary, and these preliminary hearings are presided over by an adjudicator. Excuse me. Okay, let's move on then to the hearing itself. So at the hearing, the participants are going to include the applicant, the respondent, perhaps interveners, such as the Human Rights Commission, right? They're open hearings, which means that they can be observed by anyone within the body of the tribunal. Media would often be there, particularly if it's a huge case that deals with public interest. And of course, witnesses would be available and around as well. An appearance sheet is required to be signed at the start of the hearing. And these hearings progress in very much an adversarial-like manner. They are perhaps a little bit calmer than a typical courtroom, but they are certainly very procedurally driven, more than some of the other tribunals that perhaps we have discussed, okay? And then witnesses are called, and the adjudicator will ask any questions if they need clarification on any of the statements or answers that one of the witnesses have given to the tribunal, okay? It's also the adjudicator's role to begin each witness statement with the required oath. And they have a specific oath that they give at the Human Rights Tribunal. It's quoted on the slides there for you, but I'll just read it out to you here. It says, "You are about to give evidence before the Human Rights Tribunal of Ontario. The tribunal is dependent upon you to tell the truth in the proceedings. Do you promise to tell the truth, the whole truth, and nothing but the truth? Do you understand that intentionally breaking that promise would be perjury and a criminal offense under the law?" So that's what the adjudicator reads or proposes to the witnesses. Mediation adjudication is mentioned on the slides, and this is a unique aspect to settlement of a matter before the Human Rights Tribunal. So on the slide it's called MED-ADJ. MED-ADJ is a short form, it's just a common term for mediation adjudication. It's an approach where the adjudicator at the start of the hearing or at some point in the hearing can offer mediation. And if the parties agree, then the adjudicator can then take on the role of the mediator. So they just change their hat from adjudicator to mediator. Some things change a bit, and it enters more of a mediation-like setting in that hearing room. If it doesn't work out, then they can return back to the adversarial process, okay? Of course, in-camera hearings are optional, but most of the time these are open hearings. Decisions then are typically not offered on the date of the hearing. Usually they are reserved, and that is because adjudicators have to think about the issues on both sides, and this is human rights law they're applying, so they certainly want to make sure that they're applying the law correctly and that they have considered all of the evidence and the witness statements appropriately, right, in doing so. So they're typically reserved and then later mailed to the parties. Hearings that last less than 3 days typically receive a decision from the tribunal within 6 months. And as you know from your application that you completed for your assignment, remedies can be monetary or non-monetary, or they could even be a future compliance remedy, which requires the respondent to take action to ensure similar discrimination does not occur in the future. This tribunal can award compensation for injury to dignity, feelings, and self-respect. And this is also a remedy that we haven't previously seen before other tribunals. And that is found at section 46.1, subsections 1 and 2 of the code. All orders of the tribunal are enforceable through the Superior Court of Justice. So the last point I wanted to just make about this is that The Human Rights Tribunal and the Human Rights Code, I should say, is remedial legislation. Remedial means that the tribunal's aim is to fix the problem, not to punish. It's not punitive in nature. And so this is why the tribunal will try to compensate for issues such as loss to dignity and feelings and self-respect, okay? And they also are able to make that future remedy compliance or future compliance remedy to ensure that further discrimination will not occur. And again, that's the result of the remedial focus of this legislation. I'm just going to stop it here, and we'll pick it back up with the second half of these slides momentarily. Thanks.